Well, hello and welcome to Greenway Chambers, mostly virtually, but we do have a few people here in our boardroom, so thank you very much for coming, the HWLE representatives. And we're here to talk today about the new Design and Building Practitioners Act that came into force on the 11th of June this year. It contains a suite of measures to deal with building design and building practitioners, the requirements for declarations and certificates, a series of offences, remedies and requirements for people to be registered and insured for the purposes of undertaking building work. And this is all obviously in the context of very high profile cases of defective works in large developments such as Opal Towers and Mascot Towers. I'm here today with my colleague Fahim Anwar. Hello Fahim.
G'day Frank.
And we're going to go through the Act with you. We will get to what I expect to be the most interesting part for most of those of us that are joining us, which is the new statutory duty of care that exists under Part 4 of the legislation. But before rushing to the most interesting part, we'll go through the formal requirements and address also the remedies and the offences that exist under the Act. Now, I'll pass over to Fahim for the moment. We'll try to make this as interesting and as interactive as possible, rather than just be a sitting down talking type approach. But I will pass over to Fahim to start with looking at parts 1 and 2 of the Act. We've got the structure up here. As you can see, part 1 is the preliminaries. Part 2, regulated designs and building work. Part 3, engineering and specialist work. Part 4 is the duty of care, and parts 5 to 8 is registration, investigations, enforcement and offences. So, Fahim, over to you. Where do we start?
Thanks very much, Frank. And welcome everyone. So I'll briefly take you through the regulatory aspects of this new legislation. Now, there is a detailed paper which Frank and I have prepared, which I assume will either be sent to you or will be available from our website, which will have a lot of these details. I don't necessarily propose to go through these sections in any great detail, but as I understand, we have the technology for you to ask questions or make any comments or as we go along, so please do so, whether you are joining us remotely or whether you are here in person. So I think the first point to note about the regulatory requirements is these do not come into effect until 1 July 2021. So there is quite a bit of time, and the reason is, as we will see, a lot of the details of the regulatory regime are actually in the regulations, which have not been made available as yet. And the government has said they're going to engage in quite a bit of consultation with industry and other stakeholders in developing that regulation. So a lot of the details of the regulatory regime will become clearer over time. And
can you pass me the clicker and I'll click out
absolutely
our slides across.
Will become clearer over time. But the way the new legislation is intended to work, it effectively introduces a number of new categories of practitioners in the building industry, one of which is a design practitioner. Now, the definition's up on the slide, so I won't read it out, but the key thing to note is it refers to someone who prepares regulated design, and regulated design in turn is sort of defined broadly under the legislation. So in effect, any person who designs any aspect of any building is likely to be captured by the definition of a design practitioner.
Most of these terms that you've referred to up here, Fahim, such as regulated design, building element, building work, are all defined within the Act. So it'll be necessary when looking at these matters, even though they're not identified by any inverted commas, to see how they're actually addressed. And all of those definitions cross-reference then the regulations. So as you were saying, Fahim, the regulations will have a lot of work to do in this space, and they will be the subject, as you say, of consultation and probably enactment in the first part of next year.
That's exactly right. And so, but I think, assuming you're captured by the definition of a design practitioner, so if you could just click the next slide, Frank. The key obligation of a design practitioner is to provide what the legislation calls a design compliance declaration. So if you prepare a regulated design, which as Frank mentioned is a defined concept under the Act, and give it to someone for use in connection with the building, you have to provide one of these declarations. Not only that, every time there is a change to the design, you need to provide a new declaration. And the intention behind these declarations is to clearly identify who is effectively, if I can use the word, signing off on that aspect of the design. Now, exactly what the contents of these declarations are going to be, we don't know at this stage. Details will be provided in the regulations, and this is one area where more details will come. However, the Act does say it will need to say whether or not the design complies with the BCA, and it will need to say whether any other standards, codes, or other requirements have been applied in preparing the design. So those are two things which will need to be covered. Now, if we go to the next slide, Frank, the next category of practitioners that the legislation introduces is someone called a principal design practitioner. And the idea here is in most sort of complex construction projects, there's going to be a number of different elements, often designed by a number of different people, different consultants. And the responsibility of the principal design practitioner is to coordinate the design of these different elements and effectively provide one single sign-off for the entire design. Now, just like if we click onto the next one, just as design practitioners have an obligation to provide a declaration, so does principal design practitioner. And they need to make sure that a compliance declaration has been done for each regulated design for the relevant work. And they also need to make sure that the compliance declaration provided by the different design practitioners are registered, and their registration authorises them to provide those declarations. And in addition to sort of making sure that the design practitioners are doing their job properly, they then have to provide what's called a principal compliance declaration, effectively signing off on the entire design. Now again, the details of exactly what's going to be in the declaration will be in the regulations, so we don't have a lot of details in that respect as yet.
I think there are a couple of interesting points about this whole regulatory scheme or the requirements for these declarations, in addition to what Fahim has averted to already. The first is that there are a suite of penalty provisions in these parts of the legislation which provide for maximum penalties of anywhere between 1,500 penalty units up to 2,000 and more penalty units in the event of some breach of these requirements for declarations. And the other very important thing is that each and every design practitioner is required to be indemnified or adequately insured in respect of these obligations under the terms of the Design Building Practitioners Act. So, for example, Section 11 requires registered design practitioners to be indemnified by adequate insurance, and Section... I had it a moment ago. Section 13, no, that's the unregulated.
What will the insurance cover be for?
For the adequacy, I expect, of these declarations and whether or not they comply or not. I mean, most people will already have PI insurance that would be required. But nonetheless, there is now a statutory obligation as opposed to a commercial reason to obtain adequate insurance. And it's a penalty, for example, for registered design practitioners to provide these declarations, that is to say, provide a design compliance declaration or hold out that the practitioner is adequately insured with respect to the provision of the declaration or that work, unless they are in fact adequately insured with respect to the declaration and work. As I say, that's section 11, subsection 1 of the Act.
Yeah, I think all the legislation says at the moment is you have to be adequately indemnified, so it's not clear again.
That's what I'm talking about.
Yeah.
Because your professional indemnity insurance covers you for a failure to take reasonable care. Ordinarily, that's how it's phrased. But here you're dealing with a separate obligation of insurance in relation to signing this declaration and query whether or not that marries with what your ordinary PI insurance is.
I'm just not sure. We might have a technical issue. I'm not sure if people can actually hear what you're asking us. So, what Paul Deschamps of HWL Ebsworth is asking is whether the insurance provisions that exist under Section 11 and Section 14 of this Act, which require adequate insurance with respect to the provision of a declaration or that work, really add anything in the context of practitioners of this kind ordinarily being indemnified by way of insurance, their professional indemnity insurance, to take reasonable care. Is that correct?
That's correct.
Yeah. And at this stage, it may very well be subject to the regulations as to whether or not this is any additional matter, but it would of course be a matter of the insurance policy and their terms as to whether or not the current forms of the insurance provisions would cover these additional requirements as introduced by this legislation, and which will come into effect in July in 2021. It may very well be that there's simply an additional term in the current PI insurance of most, if not all, design practitioners to cover this sort of thing.
Okay. So the final category of building practitioners, or final category of practitioners contemplated by this legislation is building practitioners. And again, it's defined broadly as any person who agrees to do construction work under a contract or other arrangement. Now, we won't go into the details of the definition, but I will just flag the fact that the Act expressly contemplates that if you're doing building work within the meaning of the Home Building Act, it's captured by this definition. And the Home Building Act has quite a detailed definition of what building work is, so that's something that's worth looking out for. Again, the definition of building work, unhelpfully it says, will be the regulations may either include additional categories of buildings which are excluded from the scope of the definition of building work, or specified in the regulations. So we won't have a very clear idea of exactly what is going to be certainly excluded from the definition until the regulations are made available. So this is another area where it's a watch this space, basically watch this space to understand what's going to be in or out. But the way the regime is meant to work is before an application for an occupation certificate is made, the legislation imposes an obligation on building practitioners to issue a building compliance declaration, effectively signing off on the building work, provide a list of subcontractors who worked on the building and the various aspects that they worked on, just as any other document required by the legislation. An application for an occupation certificate is made. And to enable the building practitioner to do that, there is a similar obligation on the developer before they apply for an occupation certificate to notify the building practitioner that they're going to apply for an occupation certificate. And the certifier who is considering whether or not an occupation certificate is going to be issued The legislation provides that they must not issue an occupation certificate unless they've got all of the compliance declarations, and they must consider any instances of non-compliance mentioned in the compliance declaration. So the way regime is intended to work is effectively, if you don't have all of your declarations ticked off along the way, it should ultimately hold up the provision of the occupation certificate. And that's really where the ultimate accountability comes in. And it will certainly be of great interest to all of the developers to make sure that that's all done so that they can get their OC in time. Now, in terms of the building compliance declaration, again, all we know is it will need to say whether or not the design complies with the requirements of the BCA, and whether or not, if it doesn't, what steps need to be taken to make sure it's compliant. Beyond that, we don't really know exactly what's going to be the contents of the declaration. So again, this is another aspect that's going to be fleshed out with the regulations. In addition to that compliance regime, though, the legislation does also impose a positive obligation on a building practitioner to make sure that essentially that the design has been prepared by a registered design practitioner and that they have provided the required compliance declaration, that it complies with the BCA, and effectively all applicable compliance declarations have been obtained along the way. And as Frank mentioned earlier, if you fail to do any of those steps, not only will there be a delay in getting the occupation certificate, you'll actually be committing a breach, or an offence actually, under the legislation if you fail to do any of those steps.
Yes, so some of the penalty provisions which apply with respect to the obligations of a building practitioner in this regard are quite severe. So, for example, there is an obligation to take all reasonable steps to ensure that each regulated design for the building work is prepared by a registered design practitioner under Section 18, and the penalty for failing to do so is 3,000 penalty units. Under Section 19, the builder must not, except with reasonable excuse, carry out any part of the building work for which a regulated design is to be used unless a design has been obtained from a registered design practitioner, which includes a design compliance declaration, and that incurs a penalty of 1,500 penalty units. And in respect of the need to comply with the Building Code of Australia, that carries a penalty of 3,000 penalty units in the event the builder does not do building work and does not take all reasonable steps to ensure that that work complies with the BCA or the Building Code of Australia. So quite significant penalty provisions.
Pretty serious consequences if you fail to comply with those provisions. Okay, so very briefly, the Act also deals with professional engineering work and also what it calls specialist engineering work, and it basically prohibits a person from carrying out professional engineering work unless you're registered and you're authorised to do so by virtue of your registration, or you are doing it under the supervision of someone who's registered. And again, as with everything else, it's an offence if you do professional engineering work without having that registration. And a very similar regime applies in relation to specialist engineering work as well. Now, the final aspect I wanted to touch on briefly. So parts 5 to 8 of the legislation deal in quite a bit of detail with registration, investigation, and the enforcement of these provisions of the legislation. Now, we've dealt with that in quite a bit of detail in our paper, so I don't propose to take you through them now. I will just make, I think, 3 brief points. So the first point is, under this new legislation, all of the different types of practitioners we've talked about, they must all be registered. And again, it's an offence for them not to be registered. The registration process is still being worked out, and the Secretary of the Department of Customer Service has been given the power to set up the registration process. So more details, again, will be made available there. The second point to note is, we've talked a little bit about the failure to comply with the obligations under the legislation constitutes an offence. But one important thing to keep in mind is where the obligation is on a corporation, a director of the corporation can be found personally liable if they have knowingly authorised or permitted a contravention of the Act. So there may be some pretty serious consequences for directors of organisations if the organisation is found not to have complied with their obligations under this legislation. And the third and final point I wanted to make is there's the powers to investigate and enforce the new legislation are pretty broad and in many cases pretty coercive. So the Secretary can require parties to produce documents. They can effectively, essentially almost issue search warrants authorising search of documents in particular premises. They can require people to attend and answer questions, things like that. They also have the power to take disciplinary action against practitioners. So it is a legislation with a fair bit of teeth in that respect. So that's really all I propose to say about the regulatory aspects of the legislation. I'll now hand over to Frank to talk a little bit more about the duty of care and the changes introduced by the legislation there.
Yes, thank you, Fahim. Obviously, one of the most significant parts of the legislation is the introduction by Part 4 of the statutory duty of care. It is significant for a number of reasons, not least of which, firstly, it represents a legislative reaction to the tide going out at common law with respect to any duty of care with regards to the performance of building works or design. And secondly, it also has retrospective operation by virtue of the savings and transitional provisions, such that it applies to building work undertaken in the 10 years prior to the commencement of Part 4. So any proceedings that are currently on foot could be susceptible to amendment by the plaintiff to introduce this new claim, not only potentially against the defendant or defendants that are currently engaged in the proceedings, but others who may have breached this duty of care. I should say at this point, I will come back to this, but although the legislation has operation for a 10-year period retrospectively, it is, at least by reference to the notations in the legislation, still subject to the ordinary limitation periods which exist under the statute of limitations, and also the Environmental Planning and Assessment Act, the long stop provision, which is now section 6.20 of that legislation, formerly 109ZK. But before looking at what the statute has brought by reference to Part 4, we thought it might be useful just to look at how the common law has developed over the course of the last 25 years or so, starting with Bryan and Maloney. This was one of the judgments, or last judgments, of the Mason High Court, which dealt with a claim against a builder who constructed a house, and sometime after construction the house was sold, and the subsequent purchaser found cracks in the walls of the house and sued the builder on the grounds that the dwelling had been built with inadequate footings. The claim was for a diminution in value due to the existence of these cracks. Now, the majority of the High Court held that a professional builder who constructs a house for the then owner owes a duty of care to subsequent owners to exercise reasonable care to avoid pure economic loss, and the relationship between the professional builder and a subsequent owner, like the relationship between the builder and the first owner, is characterised by the assumption of responsibility on the part of the builder and the likely reliance on the part of the owner. And it followed that, as was the case in the relationship between the builder and the first owner, it should be recognised as possessing the requisite degree of proximity necessary to give rise to a duty of care. Now, the majority in the High Court also referred to public policy reasons why a duty of care should exist, mainly around the ability of the builder, by virtue of superior knowledge, skill and experience, to avoid and guard against the financial risk posed by latent defects. Following the decision in Bryan and Maloney, there was a case that was not a building case called Pear or Perry and Appand, and in that case, and by reference to decision in Caltex Oil, the question of whether or not a common law duty could arise in the context of pure economic loss became focused on the notion of vulnerability. And in the decision of Woolcock Street Investments and CDG, the majority of the High Court found that a consultant engineer who designed the foundations of a building did not owe a duty of care to subsequent purchasers of that building to take reasonable care to avoid pure economic loss. It was held that there was no duty to subsequent purchasers because there was no duty to the original party to whom the contract had been made, although there were some particular facts in this case because the owner in that case had decided not to undertake certain geotechnical investigations so that the position of the engineer couldn't be confirmed. Nonetheless, in Woolcock, it was decided that the decision in Bryan and Maloney could be distinguished as the relationship between the engineers and the original owner was not characterised by an assumption of responsibility by the engineers and known reliance by the owner, given, as I say, that the original owner had asserted control over the investigation by refusing to pay for certain geotechnical assessments. As a result, the majority found that the reasoning in Bryan and Maloney did not apply. It was observed, however, by the majority in Bryan and Maloney that where there has been an assumption of responsibility and a known reliance, those cases could sit within the notion or concept of vulnerability, so that where one had a specialist engineer providing services that were known to be relied upon by someone who didn't possess that knowledge, then nonetheless, notwithstanding this particular case, there was vulnerability and a common law duty could then arise between the owner and the specialist engineers providing those services. And indeed, in two decisions that we've cited in the paper, since Woolcock, and indeed since Brookfield, which we'll come to shortly, the court has held that given the nature of that relationship and the fact that specialist services were being provided and there was known reliance on those services, in that case by a builder, with regards to a design and construct contract, there was a common law duty of care owed by those engineers, in that case to the builder. And the decision that I have in mind is called Zeneros Investments and Walker Group Constructions. It's a decision of Justice Ball from 2016, but as I say, we've given a full citation in the paper. So in Woolcock, one could see the tide moving against there being a general common law duty and the public policy reasons which concerned the majority in Bryan and Maloney, and it moved more towards the ability of a party who is receiving services to protect themselves, and indeed subsequent purchasers' ability to protect themselves by negotiating terms, seeking indemnities, qualifying whatever was being purchased by their commercial arrangements. And as I say, that notion flowed from the decision in Perry and Appand, not a building case, but a case which nonetheless concerned pure economic loss and a common law duty to exercise reasonable care to avoid such loss occurring. We then reached the position in 2014 of Brookfield Multiplex and the Owners Corporation Strata Plan 61288. Now, I'll take it that most practitioners in the building field will be quite familiar with this decision, so I won't dwell on it. There were four. I thought four, but I always forget
Actually,
Justice Gagler. There were four decisions in Brookfield which dealt with the claim by the Owners Corporation for defects associated with latent conditions and a claim made pursuant to an asserted common law duty. Now, each of the judgments rejected the claims of the Owners Corporation and found in favour of Brookfield and concluded that there was no claim available in negligence. Again, the concept of vulnerability and the notion of the ability to protect oneself against such loss and damage featured heavily in the decisions, together with the fact that the court was concerned that the rights of the Owners Corporation and indeed subsequent lot owners were already governed by statute. So there were available remedies under the Home Building Act which allowed for successors in title to take action and which prescribed what those rights were, including when and how such claims could be brought. And in those circumstances, there was a reluctance to conclude that the common law ought to step in and introduce additional or wider rights where the legislature had already determined the scope of remedies for persons and an owners corporation in this position, and in those circumstances determined that there was no common law duty that was in existence. Indeed, there was no common law duty that existed between the builder and the original developers, and in those circumstances there was no available claim at common law. So by 2014, we'd reached the point that at common law the rights were prescribed by the contract or as provided for in the case of residential building work by the Home Building Act in New South Wales and by cognate legislation in other jurisdictions and territories throughout Australia. Then, of course, we had the Christmas Eve Opal Tower incident, which obviously at a slow news time occupied a lot of people's attention. We've since had Mascot Towers, we've since had other developments the subject of some publicity, and the New South Wales government felt it necessary to take some action in these circumstances to provide for, it seems, additional rights where, as a result, as I say, of the tide of authority coming out of the High Court, it was really left to the legislature to act to add to whatever might be otherwise available in contract. So hence we have part 4 of the Design and Building Practitioners Act 2020, which introduces a statutory duty of care. Now, as with many parts of this legislation, a lot will depend upon what comes out in the regulations. The first part of the relevant new provisions is section 36, which provides a series of definitions, including a second definition of building work, given that there is already a definition of building work under the terms of the Act in section 4. It was thought that it was so much fun they'd do it twice, so they gave us another definition of building work in section 36 subsection 1 to not so much add or qualify the definition earlier, but I at least think simply to make clear that it includes what is called residential building work within the meaning of the Home Building Act. Now, practitioners who may be familiar with the Home Building Act will know that the definition of residential building work is in fact quite comprehensive and runs over a number of pages, It is to be found in Clause 2 of Schedule 1 of the Home Building Act presently. But what's interesting is that it actually includes a number of exclusions. So it actually says that this is not residential building work for the purposes of the Home Building Act. And one thing, at least that occurs at the moment, which it seems is unresolved, is whether or not what is excluded as residential building work by the Home Building Act is nonetheless building work for the Design and Building Practitioners Act, because when one has regard to the scope of the definition of building work in Section 4, there's not much which isn't. So, although I think, I was looking at this afternoon, demolition is excluded as residential building work under the Home Building Act, and it would be doubtful, I think, to include demolition as building work under Section 4 as work involved in the construction of a building, the making of alterations or repair and renovation. So that's one item that might still be outside the terms of the legislation. But there are many others, including temporary buildings, movable dwellings, all these sorts of things, which are excluded under the residential definition, I should say, of residential building work in the Home Building Act, but maybe within the definition of building work under this Act. So the definitional provisions will be important, and again we await to see what happens with the regulations associated with that. In this regard, it should also be noted that the duty of care relates to construction work, not building work. And construction work is actually also defined in Section 36(1) as meaning A, building work. Query whether that's building work under Section 36 or building work under Section 4, possibly both. It is also, construction work also involves the preparation of regulated designs and other designs for building work, so it's not simply covered by those earlier regulatory provisions. Other designs are also captured by the definition of construction work. The manufacture or supply of a building product, supervising, coordinating, project managing, etc. And in those circumstances, the duty of care, which we'll come to in Section 37(1), which concerns the carrying out of construction work, may have a lot of work to do, even extending to people making bricks, fabricating cladding, fabricating glass, all those sorts of things that go into a building at the end of the day. Owner is very broadly defined as well. I won't run through them all, but it's there, and owner is also an owner's corporation for the purposes of the Strata Schemes Management Act. It includes community schemes, etc. Now, Section 37 is actually entitled Extension of Duty of Care. Titles obviously don't have any operative effect. They're simply there as signposts in legislation. But Section 37(1) stipulates that a person who carries out construction work has a duty to exercise reasonable care to avoid economic loss caused by defects in or related to a building for which the work is done and arising from the construction work. In this regard, it should also be noted, going back to the definitions in subsection 2, that a reference to building work in Part 4 applies only to building work relating to a building within the meaning of this part. And building is given the definition, or adopts the definition, I should say, as it has in the Environmental Planning and Assessment Act. The duty of care is stipulated to be owed to each owner of the land in relation to which the construction work is carried out, and to each subsequent owner. And the person to whom the duty of care is owed is entitled to damages for breach, as if the duty were established by the common law. Now, that may very well be important. There are occasions where the right or remedy of damages, where one is suing at common law rather than suing in contract, may be different. Ordinarily they are the same, that the principles in Belgrave and Eldridge are usually said to apply to both, but there are occasions where it may be different, particularly where issues of reliance arise, and when and if knowledge was had of the particular defects. So the remedy will be damages at common law or in tort, rather than, that is to say, reliance damages, rather than damages in contract, which is usually defined by the shorthand expectation damages. And the duty of care is owed to the owner whether or not the construction work was carried out under a contract or other arrangement, or indeed otherwise than under a contract or other arrangement. It's not clear what they had in mind there, or whether work was performed under not a contract or not other arrangement. Maybe it's work that's given voluntarily. That there is no arrangement at all. Someone simply says, I will build you a house, or I will build you an extension for free. And nonetheless, even without any remuneration, consideration or compensation, the duty is still owed. And you, or a building practitioner, or indeed anyone caught by this duty, may be liable even though it's a gift. And that is obviously something that needs to be considered. In section 38 we have what is economic loss, and it provides that an owner's corporation is taken to have suffered economic loss for the purposes of the part if the corporation or association bears the cost of rectifying the defects. And we know that an owner's corporation has an obligation to repair defects in common property under the Strata Schemes Management Act, and lot owners may be required by way of special levies to pay for such rectification. So those persons, having regard to their obligations to undertake the works, and lot owners who have to pay for them, will be entitled to recover those damages. And indeed subsection 2 of section 38 includes expressly that the economic loss suffered includes the reasonable costs of alternate accommodation. So one of the often debated elements of a claim associated with defective building works is what do you do while the building works are being undertaken? Do you stay in your house or your unit while tradies traipse through and repair various elements, or are you entitled to some alternate accommodation for some period of time? And are you entitled to get some form of damages for that? And section 38 subsection 2 expressly provides that the cost of alternate accommodation is included as economic loss. These sections, it should also be noted, don't limit what may be recovered by way of economic loss for owners, corporations and associations. Section 39 is a very simple provision. It simply says that the duty of care cannot be delegated. Section 40 provides that there is no contracting out of this part, and that this part applies despite any contracts or stipulations to the contrary made after the commencement of this part. Now, I might pause at this point and note that we kindly received a question from Saba Amir Gudazi about the operation of this provision and how it would apply to existing or new caps on liability clauses. And the example that was given in the question that was kindly provided to us was in respect of cladding. And the query obviously concerned the retrospective nature of the new statutory duty of care. Now, in our view, in the time available to consider the question, we think the answer is to be found in section 40, subsection 1 and 2, which refer to the prohibition on contracting out to contracts or stipulations made after the commencement of this part. So if there is a project currently going on, or indeed has been completed, where there was a limitation of liability or a cap on damages, because it was not made after this part, but it was made under the law as it then stood, it would not offend section 40 and that proscription or prohibition against contracting out. But as far as new contracts are concerned for new projects, those caps on liability or attempts to contract out may indeed fall foul, or at least not be able to be relied upon in answer to a claim made pursuant to this statutory duty. So we hope that's addressed the question, that contracts that presently exist or projects which have been completed would not be caught by Section 40, but in future, and having regard to the fact this part has already commenced, any such contracts would not be a defence or a limitation of liability with regards to the statutory duty. Did you have a question about that, Paul?
Well, just most limitation of liability clauses commence with the words except to the extent required by law. So there's already a carve out in, if it's a legal requirement, you can't contract out, doesn't matter whether it's now or in the future retrospective, it still becomes the law, so it still applies.
Yeah, no, that's a very good point. Paul Deschamps makes the point that most limitation of liability or caps on liability clauses already use the words in the chapeau to those clauses, except to the extent prohibited by law, there shall be a limitation of liability or an exclusion of liability. So they already accommodate this sort of provision. But nonetheless, to the extent that there are those out there that don't, that's where we think the legislation is at. It's not trying to negate agreements that have already been made or applied to projects that have already been completed, but it requires that for new projects and new contracts, those sorts of arrangements or terms will not be effective in answer to a claim under this statutory duty. The next section, section 41, the last section of part 4, deals with its relationship with other duties of care and the law, and it makes it clear in subsection 1 that the provisions of the Act are in addition to duties, statutory warranties and other obligations imposed, including by the Home Building Act and other legislation, and at the common law, and do not limit those duties, warranties or other obligations. It should also be noted, I think importantly, that subsection 2 does not limit the damages or other compensation that may be available to a person under another Act, and subsection 3 stipulates that the part is subject to the Civil Liability Act 2002, which means that it is subject to the apportionment regime that exists with respect to these sorts of claims. So in the event that there was a claim made against one party, it would be possible to identify other parties as concurrent wrongdoers so as to thereby have the claim for damages or the damages award limited by that apportionment regime. As I've already indicated, there is a notation, although not a provision of the Act, that states that actions under this part are subject to the applicable limitation periods established under the Limitation Act and Section 6.20 of the Environmental Planning and Assessment Act, which relates to civil actions relating to certain work. So I think one can proceed on the basis that even though it has 10-year retrospectivity, there may very well still be defences available pursuant to those legislative provisions having regard to the nature of the claims. So we can see that in the face of the events that have occurred and been the subject of media attention over the last 18 months to 2 years, the legislature has taken the step of reintroducing by way of statutory measure that which the High Court had determined was not as available, generally speaking, by reference to those decisions in Woolcock and Brookfield. As I've already indicated, the provisions of Part 4 apply retrospectively, so that they apply to projects completed over the last 10 years, and that is to be found in the Savings and Transitional Provisions, Schedule 1, Section 5. And that makes it clear that Part 4 extends to the construction work carried out before the commencement of Section 37 for the owner of the land and to subsequent owners where the construction work has been carried out. and that it applies to economic loss caused by a breach of the duty of care under that sub-clause if the loss first became apparent within 10 years, immediately before the commencement of section 37 or after that section. So the legislature has determined that there is a new cause of action available, a statutory duty of care, albeit described as an extension of the duty of care in section 37. It is an action which is founded on the common law, and the remedy is one for damages at common law, and it is one that, as I say, applies for building work and economic loss suffered in the last 10 years. That's really the summation. We're yet to see how it develops. We're yet to see how the regulations affect its development, but it certainly represents a significant addition to the armoury of claimants who have suffered economic loss as a result of defective building works. And I'm certain that it will result in a lot of litigation. So that's all I wish to say. Fahim, did you want to add anything about our new statutory common law duty, or have I droned on long enough?
No, look, I think we've sort of covered most bases. Did anyone have any questions, either here or those of you who are joining us remotely? No?
Yes, Adele.
There seems to be two schools of thought at the moment with respect to Part 4 and whether it applies now. So Parliament has said that it has commenced. However, with reference to the building work definition, Section 4 referring to classes of buildings, and obviously that refers to regulations which haven't come into effect. So there's one school of thought that seems to be swirling that says, therefore, because there is no scope for Section 4 at the moment, therefore because that informs set building work definition in Part 4, therefore Part 4 now has no work to do. But there then seems to be a second school of thought that is swirling around, that because of the word includes in the definition of building work in Part 4, it therefore must be, as a basis point, that it must refer to work, a residential building work now for the purpose of the Home Building Act.
Okay, so just to summarise for those that perhaps couldn't hear, the question is whether, because Section 4 of the Act refers to regulations which may affect the question of the building work which is covered by the legislation, and those regulations haven't been written or enacted yet. Nonetheless, as a result, the part actually has no work yet to do. The alternative is that, well, there are definitions self-contained within Section 36 which deal with the question of building and building work, and therefore there is no need to consider that there is nothing occurring. I personally don't think much of the first argument for a couple of reasons. Number one, the definition of building work in Section 4 is contained within subsection 1 and says building work means work involved in construction, making of alterations, etc. Subsection 2 then says the regulations may prescribe additional work or exclude work. So it may or may not happen. Now, the suggestion that because there is some possibility that it may or may not happen, there is no work presently covered, or there is no building work, quote unquote, as under Section 4, it seems to me is not going to be an argument that finds great favour. And secondly, I also agree, or at least I think that I agree with the second school of thought, which is, well, the definitions are there under Section 36. You have a definition of building, which is an adoption of what's in the Environmental Planning and Assessment Act. You have a definition of building work to at least include residential building work. And you have in Section 2 a statement that says a reference to building work applies only to building work relating to a building within this part. I think you've got some pretty clear guidance or certainty as to the operation of this legislation, if you're hanging your hat on the possibility that the regulations may do something or may not do something in the future, then you might want to find a second string to your bow.
And I'll just add, I mean, I agree with everything Frank has said, but in addition, if you look at section 2, the commencement section, it makes it pretty clear that the intention of the legislature was for certain things to not commence until 1 July 2021 and for other things to commence immediately. So it seems to me any suggestion that just because things may change due to regulation, there is a clear legislative intention for Part 4 to have commenced already, and we have to give some meaning to building work within that part.
Which I think is pretty easy to do.
Exactly.
How we go down the back there, Matt? No questions? All right. Well, look, thank you very much for joining us here at Greenway for this new legislation. It's certainly going to be an interesting ride that we've got in front of us in terms of how this Act applies and when it comes into effect. Please go to our website and download the paper. And if you have any questions about any aspect of the legislation or indeed anything else, please don't hesitate to get in contact with Fahim or myself. Thank you very much for joining us this afternoon.
Thank you, everyone.